Well, welcome everyone to the next session where Jeff Podjanowski and Kevin Walsh will be talking with us. And Kevin, are you on the line?
Indeed I am. Thank you.
Well, welcome.
Coming live from the Walsh family spare bedroom, we have my disinvited co-author, Kevin Walsh.
Excellent. So we'll have the two of you, and then Mitch Berman's going to commentate after that. So take it away, Jeff and Kevin.
Well, thank you very much. So as we enter the 8th hour of our Works in Progress conference, it's fitting that we discuss a paper called Enduring Originalism, because that's what we've been doing for a while. Although, thankfully, John Sinifer's paper is sufficiently good that it'll be neither cruel nor unusual to read his next. So our paper, basically explains, provides kind of an alternative justification for why at least Kevin and I think originalism is a not just a plausible but a good approach to constitutional interpretation. And I think one of the contributions that we bring to the debate is bringing the perspective of the classical natural law tradition to constitutional originalism in ways that a lot of the times the standard debate doesn't think about. And we do it in two ways. One is looking at the kind of methodology, the kind of jurisprudential methodology to theorizing about social practices that a lot of practitioners in the natural law tradition bring to kind of the what is law, what is the relationship between law and morality. We bring that to bear. And then we kind of deploy kind of classic natural law reasoning to identify, in light of why we have law and law's moral purposes, why originalism, at least in our particular constitutional order, is a good way to go about constitutional interpretation. And then we kind of close off with, we don't offer not even a full-blown theory of adjudication. That's going to be the next paper, and we haven't written it because we don't know what we're going to say yet. But we think we say, well, where do these kind of considerations bring us today, and what is the choice about whether one should endure as an originalist or not? So the first point, I guess the first part, we can basically kind of positive law, positivism, and jurisprudential methodology. And here's where we kind of bring the natural law methodological toolkit to arguments about legal interpretation. Now, we find ourselves in large agreement with the building blocks that Will Bode and Steve Sachs bring with respect to their particular brand of originalism, their original law originalism. If you want to use the metaphor of a house, we really like the house they've built. We like the furniture that they've supplied. But what we're trying to do is provide what we think is a more secure normative foundation for that approach to doing it. Earlier, Randy used the analogy that Will and Steve are maybe the kids telling the grown-ups to start arguing. Well, maybe we're brothers picking a fight with them, but in the end, we all want to get in the station wagon and go see Santa Claus. We're brothers, and we're on the same page. But what we're trying to think about why methodologically we think an approach similar to that is a good thing. And two problems, and our point of disagreement is kind of on the jurisprudential foundations, the Hardy and positivist framework they use. And this is, our critique is not a new move. It's John Finnis's critique of Hart in the first chapter of Natural Law and Natural Rights is applied to constitutional methodology. The first is the problem of describing the law of interpretation or interpretive practices non-normatively. We think there's the question Hart's internal point of view. If there's multiple plausible internal point of views, you need to pick whose internal point of view matters. And in any system of substantial complexity and pluralism, description alone is not going to get you there. And we think you need an evaluative approach to pick out what counts as good instances or better instances or defective instances of constitutional interpretation. The second point where we bring to bear under this heading is what we maybe call the problem of inertness. Let's say there is substantial disagreement that our approaches to interpretation are all this way. On purely positivist grounds, it doesn't give you a reason about why you should continue to be that way. You can say, someone can say, well, our law is originalist or is non-originalist. Our rule of recognition is non-originalist, and if I'm insurrectionist judge and says, you know what, I want to invalidate paper money, you would say, well, that's not our law of interpretation. I'd say, well, that's very interesting. I'm just going to do it anyway. And if enough of me go along, you know, we change the facts on the ground and I win. So one of the questions is, why do you need to be faithful to I guess one way of thinking about it is, why do we need to be faithful to the rule of recognition? If our rule of recognition is originalist, why persist to be originalist, even if we all agree with it? Now, our second point is kind of moving to kind of give natural law foundations to what we call positive law originalism. So we understand, you know, we kind of go back to the, you know, musty old natural law tradition and the classical understanding of law as an ordinance of reason for the common good, made by a person with the care of the community and promulgated. Well, you know, reason and the common good. I guess one of the main insights we bring here, and where this looks different than a lot of natural law reasoning in constitutional discussion, is we distinguish between the role the natural law plays for a framer of a constitution and the role that the natural law plays for an interpreter or an applier of the Constitution. And we would say once, you know, there is good, you know, rule of law, basic kind of natural law reasons about why we need to have a reasonably durable legal framework. The natural law doesn't provide one, you know, glowing constitution in the sky that if we don't pick, we've violated the natural law. There's going to be a wide range of reasonable constitutions we have. The natural law and reason underdetermines which one we have, and it's going to vary. You know, the wisdom of one is going to vary depending on our, cultural context, et cetera. But and there are going to be some constitutional regimes that are not worth, you know, having. But once we pick one that falls within the realm of reasonableness, given the need for coordination, cooperation, reasoned dispute resolution, settlement, all those good rule of law things, the natural law traditions, there's a strong moral presumption of maintaining and being faithful to a reasonably just legal system. And so we would say, when you're a framer of a constitution, you appeal to first order reasons about what kind of, you know, constitution we ought to have. But once a constitution is fixed and set and durable, the natural law speaks importantly to our second order reasons for why we have a constitution in the first place and why we ought to be faithful for it, even if a particular provision or a particular arrangement is not one that we would have picked as a first order choice. Again, this is a defeasible obligation, but we think it's a pretty strong moral obligation given the positive goods that a well-functioning legal system can bring to a political community. And so, going back to the question of, whose internal point of view counts, we'd say, given the central case of law as, a ordinance of reason for the common good made with someone with authority and promulgated, we think, the central case of interpretation is, the practically reasonable person would identify the authoritative choice fixed by a framer. Otherwise, the broader purposes of law couldn't be achieved. And why persist to adhere to this original law? Well, the benefits of constitutional governance to the common good. These second order reasons for being faithful to the fixed positive law we have. And then we kind of go on to argue that this is not some sort of weird medieval, import that we're foisting down, the thirds of the 21st century. We kind of go through in some detail, maybe too much, maybe too little, that this understanding of the point of constitutions and constitutionalism runs really neatly with what the framers understood they were doing when they fixed the positive law constitution. They were not kind of quoting their Aquinas as far as we can tell, and natural law is a large, complicated family. But whether if you look at the Declaration and the language of the Constitution, early debates about interpretation and conventions, early jurisprudence, early treatises, this kind of understanding of the central case of law and its enduring and fixity, that this is the kind of document that they made, is congruent with our kind of first principles arguments about why have a constitution, and given why we have a constitution, why you ought to try to identify the law that was originally put in place until it's changed. And this was largely the case until the end of the 19th century, early 20th century, when originalism fell out and we've entered a zone of eclecticism. There's a lot of not just a lot of non-originalist law out there, But there's also a lot of approaches to constitutionalism that reject this understanding of the kind of document that we have. And so we are in, that's time.
10 minutes, right?
Oh yeah, I was going to host for a warning. All right. Finally, what do we do today? I will tell you after Mitch Berman criticizes us.